over the edge of the bench.
They are low.
Good morning and welcome to Division 5 of the Colorado Court of Appeals. I hope it was not terribly bad for you to travel here today. I know some of the areas of the metro area were a lot worse than others, even though it seemed fairly clear here in downtown. Other areas were having more problems. The areas from which Judge Nieto came and from which Judge Furman came this morning. We have one case on our docket, on our 1:30 docket this afternoon. I think I said good morning, didn't I, instead of good afternoon. Good afternoon, rather. That's on our afternoon docket. We have the case of Connor versus Denver Planning Board, and that is case number 2015 CA 709. Have counsel had the opportunity to read our procedures and protocols handout, and do you have any questions about any of those?
No questions, Your Honor. No questions.
Okay. And I'll remind you that I don't think there are many sensitive pieces of information in this case, but we are being live streamed on the internet these days. So I'll remind you of that fact, and you can take that into consideration if necessary in your arguments. Also, appellant, you have the right to reserve some time, as you know, and we have self-monitoring time clock here, so you can be aware of that, so you can reserve whatever time you want to reserve. And as far as everyone else in the gallery, I would remind you that if you have a cell phone, please make sure that it's turned off, and any pagers or anything like that are turned off so that they don't interrupt the arguments this morning. And with that, unless counsel has any questions, we're ready to proceed, sir.
May it please the court, my name is Greg Kerwin, and I represent the plaintiffs and the appellants in this case. We're here today because the city of Denver contends that virtually no Denver property owners have standing to challenge unwanted high-density zoning changes in their neighborhood. The city contends in this and in two pending cases in the Denver District Court that no one lives close enough to challenge a zoning change, and no property owner will suffer sufficient injury to have standing. This argument lets the city planning department arrange zoning changes with developers based on the city's current plans to densify Denver, but it harms Denver residents. The city's mistaken as a matter of law in its attempt to escape judicial review of its zoning actions, and the trial court's dismissal decision here was wrong in its rationale and its result. Denver should respect and not block the rights of Denver homeowners to challenge zoning decisions that harm their homes, streets, parks, neighborhoods, and quality of life. I'd like to focus, of course, I'll address whatever questions the court has, but focus on the standing and the injury arguments that we presented in the briefs and that were central to the district court's dismissal decision, and also touch briefly on the ripeness issue and the Denver zoning code provision that we believe gave the trial court Rule 106 jurisdiction to review the planning board decision. First, on standing, the trial judge's ruling dismissing the claim here reflects just a few unexplained conclusions without any analysis to help you see what the trial judge was seeing. The city tries hard to fill in with some alternative analysis, although the trial judge ruled on a basis that the city did not argue for. And on standing, we would suggest that the correct question for this court's precedent that it may set in this case to ask for standing in a context like this is whether the property owner plaintiff alleged plausible injury different from the public at large, so there is an actual controversy, I think that is a fair summary of what Colorado case law suggests.
Counsel, in that regard, I'm having difficulty seeing the injury where the city has not taken action on this recommendation of the planning board. Can you explain to me how your clients are injured in the present circumstance?
Your Honor, I perceive that maybe as a mootness argument as well. Injury would be something we alleged in the complaint from the zoning action, and they withdrew the text amendment, but they wouldn't commit to not renew that. And in fact, that text amendment, now I'm arguing outside the record because these are events post-dating the complaint. After that, the city adopted a map amendment for the same Buckley Annex parcel, which simply incorporated some of the same elements as the text amendment, including very small.
Mr. Kerwin, I'm sorry to interrupt, because I need clarification, I think, as a follow-up in what you're saying.
Okay.
Is this, you're calling it a final action? I mean, does not everything have to go through the city council before it's final?
For Rule 106 review, the Denver zoning code at this time, and it's been amended in June, but that wouldn't have any bearing on this case, provided for a review of a decision on a text amendment. And you're absolutely...
But a decision by who? That's what I'm...
Didn't say. They've changed it to now, because I think they recognize in light of this case the ambiguity, and it now says a decision by the city council. But at the time this case was filed and at the time of the current controversy, it simply said a decision. Our position is that Rule 106 allows review of quasi-judicial decisions, and the planning board's decision on this proposed amendment was surely quasi-judicial.
So before the rule was changed, once the city planning commission decided the text amendment or whatever else, that's a final action before the amendment.
A final action of the planning board, yes, and we allege in our complaint that it was conflicted and flawed. The planning board members admitted on the record they hadn't done preparation. One of the members voted even though he had a plain conflict. And our position is if this court can't review that decision here, then it makes the planning board's quasi-judicial decisions unreviewable. The city takes the position after the city council has ruled that you can't go back and pay attention to the planning board because that's been superseded.
So the city council did not need to weigh in, let's say, several years ago?
I get your question, except for the several years ago, Judge Furman.
Let's say 2 years ago, before the rules were amended.
Okay, the rule was just amended in June of this year, right, after this appeal's been pending.
Okay, so
and at that time, when this case was filed, the Denver Zoning Code, which creates the judicial review provision for this, said a decision on a text amendment may be reviewed by the district court. So that's the operative language that we brought the Rule 106 claim on. And I want to distinguish, but I'm sure you know this from our briefs, we also have separate claims for declaratory judgment, the second and third claim. And the trial judge's ripeness ruling related to our first claim, a traditional Rule 106 administrative review claim. And yes, we brought it based on that Denver Zoning Code provision to specifically challenge unfairness in the quasi-judicial proceedings of the Denver Planning Board. And the trial judge found that that was not ripe and said you would have to wait until a decision by the city council, except that the moment we filed this lawsuit, the city withdrew that text amendment. We tried for a period of time, and this is in the record, to work out some resolution where the city would not reinstate it. They simply had CPD send a letter saying we're withdrawing it, but we were trying to confirm that it would not appear in some other form. And again, this is outside the record because it's events later than the complaint, but you can take judicial notice that the city did pass a map amendment in the same Buckley Annex parcel, which incorporates the same very small setbacks along Quebec and along First Avenue for 18 acres of this, and allows 5-story CMX5 zoning.
So, Counsel, those issues are not before us.
Well, we packaged our complaint. The city had packaged both the text amendment and the map amendment and was putting them up for hearing sequentially, and that was about to go before the planning board, and then they delayed it. So we think for purposes of the declaratory judgment that it is ripe, and there is a case or controversy about the rezoning of the Lowry Air Force Buckley Annex parcel, 70 acres, and whether the city's actions taken in the text amendment and in upcoming zoning that has not occurred yet are consistent with adopted plans. That's the merits issue that we're trying to get to. I'm sorry, Judge.
What if they are never adopted?
Well, there's a portion, 18 acres of the Buckley Annex parcel that needs some kind of zoning. It's currently waiting for the city to fill in the gap. And so I don't think anyone, the city or the people who live around there, think there will be no zoning changes. And the developer and the city in a general development plan have indicated a plan for a certain level of density. And so our core merits issue, which is not before you today because we got dismissed, is whether those proposed changes, partly adopted in the text amendment challenged here and partly in zoning to happen in the future, is consistent with adopted plans, including a plan worked out with the Air Force. This is all spelled out in the complaint. So for purposes of a declaratory judgment, we think there is a real case or controversy in existence now that a trial court can decide about whether the city's proposed rezoning of portions of the Buckley Annex parcel are consistent with adopted plans, which is the criteria in the Denver zoning code.
I'm still having trouble seeing it when the city has not acted on it. As it stands right now, has anything that's before us affected the development of that property? Anything that's before us, not something that could happen in the future, that might happen in the future, or in some other case. Right now, is there anything that's before us that has affected your clients?
The text amendment that was proposed and then withdrawn had setbacks which have now been adopted in CMX 5 zoning, Your Honor.
But that's a different case, isn't it? That's not our case.
We are trying to address in a declaratory judgment action the overall concept of what kind of zoning is proper for that specific parcel, Your Honor. And I don't think a declaratory judgment has to await final action by the city if there's an existing controversy, as there clearly is here from the pattern of actions by the city in the text amendment itself, in the map amendment, and in what's to come in the future.
But if the text amendment was withdrawn, that is moot. If they're coming back with a map amendment, that's not before us.
The map amendment is not before you in this context. It's already been passed by the City Council, and we did not challenge it. The plaintiffs were sufficiently intimidated. They didn't bring a second case here. And the standing is uncertain because of the ruling of the trial court here. So
but the text amendment was withdrawn.
The city told the court that it was withdrawn. We tried to clarify. I think
but that was in the judge's order. In his findings. Didn't he say something to that?
I don't remember if she specifically addressed that, Your Honor. Typically in a district court proceeding, if a claim is withdrawn, the trial judge says it's hereby dismissed with prejudice, and there's a stipulation to that effect. We tried to get the city and to agree to that, and they would not agree to anything like that. And so it was simply a letter that was put into the record saying the city's not currently pursuing it and withdrawing it from the City Council calendar.
Well, with regard to this particular case and the issue about the planning board's recommendation, and that's the one that you're appealing from, right? You're appealing from the action of the planning board making a recommendation.
In part on the Rule 106 claim, which is claim 1,
claim, right.
But there is a separate... I don't want to interrupt you, Judge.
Let me ask you as to the 106 claim then. After the planning board made its recommendation, could LRA have proceeded to develop the property legally?
No, not with it. The text amendment would have had to go through the City Council to be finally approved. Absolutely.
Okay. Thank you.
So that I hear very loud and clear what you're saying. There is a Rule 106 claim, and the judge's basis was that was not ripe, and a separate ruling on standing for purposes of the declaratory judgment action. She did not find that the declaratory judgment action was not ripe. She said there's no standing, and we're here to...
If LRA could not have gone ahead with development after the planning board's recommendation, how could your clients be injured? How could they suffer an injury in fact?
Your Honor, for purposes of the declaratory judgment, there is a general development plan that the city adopted in 2013 that it's treating as an adopted plan, and that was guiding all of the further zoning that was happening. And to give the trial courts time to address this, we thought it was appropriate to seek a declaratory judgment now, rather than waiting until all of the development is a fait accompli, because we can't get a bond once the zoning is approved to stop the development. So the test in Colorado for declaratory judgment is not wait till all the bad things have happened and then challenge it. It's wait till there's a real case or controversy. And we think, based on the allegations in the complaint, there is a real case or controversy for a declaratory judgment.
But you still have to have standing to bring a declaratory judgment action.
You do, and that was the judge's ruling.
And you have to have an injury in fact.
Absolutely. And we think we meet the...
And I'm having a hard time seeing how your clients could have been injured when all there was a recommendation out there. There's no adoption of the text amendment. LRA could not have gone out and legally developed the property based on a recommendation of the planning board. So how, explain it to me. I may be missing something.
The property is being developed in about 5 different stages with separate zoning for each stage. Several of those stages have been completed already. And the blueprint from the city's perspective for that development is a general development plan that was adopted by the planning board, but not the city council in 2013, and which ignores the community plans that came before. Fundamental to rezoning in the city of Denver under the Denver zoning code is a change to zoning must be consistent with adopted plans. And so we sought, and if you were to remand, we would seek again from the district court a declaratory judgment that the general development plan adopted in 2013 is not an adopted plan for purposes of the zoning code, and they have to look at the Air Force plan, the Lowry reuse plan, and all future zoning there needs to comply with that. There's still 18 of the 70 acres that has no zoning on it, and if you were to simply find no jurisdiction here, then we're right back to square one in trying to figure out how to hold the city accountable for zoning that is consistent with adopted plans, except that we have the trial court's decision saying you have no standing, and we have no way to challenge the unfairness of a planning board process that was conflicted and where the planning board members admitted they were not prepared. So we think there's a proper way under Rule 106 to review the unfairness of the planning board process under the Denver zoning code jurisdictional language in effect at the time, which did not mention a decision by the city council. And we think there's a proper basis under Colorado case law for a declaratory judgment. If I can hold the 1 minute or less that I have for rebuttal, I'd appreciate that.
Thank you, counsel. You may proceed, counsel.
May it please the court. My name is Karen Aviles, A-V-I-L-E-S, number 13989, and I'm here representing the defendant appellees, City and County of Denver, Denver Planning Board, and Denver's Manager of Community Planning and Development. The questions that this court asked the plaintiffs were exactly on point. You have to look at what the plaintiffs challenged. The plaintiffs challenged a planning board recommendation on a proposed but now withdrawn text amendment. They did not appeal a rezoning, which applies the words of a text amendment to the ground. What they appealed was a recommendation on a language amendment, which would have put development parameters in the zoning code if that text amendment, that language amendment, would have in fact been heard by City Council and approved by City Council. Even if that language had been approved by City Council, it would remain on the shelf until it was applied to the ground by a separate City Council action, a separate rezoning. None of that occurred in this case. You have a recommendation by a planning board, which is not the final decision maker in this case. There are actually 7 steps to adopt a text amendment. Planning board occurs at step number 4. It's only a recommendation. There are 3 steps remaining after the planning board recommendation is heard and after the planning board hearing.
Ms. Aviles, I'm sorry to interrupt. So what I need clarification on, Mr. Kerwin indicates that as of June of this year, those 7 steps were put in place. So if we go back before that, did the text amendment have to be approved by the City Council?
Yes, Your Honor. There has always been 7 steps to the text amendment process. Denver adopted a new zoning code in 2010, and this language was in there prior to, but there's always been 7 steps to the zoning process. What Mr. Kerwin was referring to was a text amendment actually approved by City Council, which clarified that the planning board was only a recommendation and that it took a decision of City Council before it could be appealed. That was only a clarification.
Well, Council, maybe you would address then why under the prior city code where it says a decision may be appealed to the district court, why the actions of the planning commission or planning board are not a decision applicable under that particular section of the code.
There are two reasons for that, Your Honor. First of all, it's a planning board recommendation. I believe it was you that pointed out that could LRA in fact have developed based upon the planning board recommendation? And the answer is no. So under the prior language, it's only a recommendation, it's not a decision. And if you take the plaintiff's interpretation of the code as it was in place before June, there are 7 steps. And their interpretation would allow an appeal at step 4, ignoring the other 3 steps that are set forth in the zoning code, which takes you to the final decision maker, City Council, who rules on step 7 after a notice and a public hearing. So the prior code had that. All the new language amendment did was to clarify that the planning board was only a recommendation and not a decision. And so that's why this really is premature. The 106A4 claim is not ripe.
Ms. Avalos, let me ask you a question. I'm trying to reconcile in my mind Mr. Kerwin's argument about the decision. A decision can be appealed to the Court of Appeals, or can be appealed, rather. It appears to me that the only way you can get there is if you say that a decision is made at each one of those 7 steps, that the planning board made a decision to make a recommendation. If that, in fact, is Mr. Kerwin's argument, and I don't know, that's the only way I can figure it out, what's your response to that? Because the planning board did have to make a decision. It had to decide to make a recommendation.
Well, Your Honor, twofold. First of all, the planning board had to make a recommendation. They did not make a decision. Only City Council can make a decision on text amendments. And the second point is that if the planning board did not act, the text amendment could have gone forward to City Council without an action by the planning board. So a planning board recommendation, it was only a recommendation. They could have taken no action, and the text amendment could have moved forward to City Council for approval, giving meaning to all 7 steps set forth in the code.
Is that provided somewhere in the code? I don't recall anything about what happens if the planning board doesn't actually make a recommendation.
The planning board is given an opportunity to make a recommendation, but on text amendments as well as on rezonings, and again, this is not a rezoning case, but on text amendments, there is no prohibition on it moving forward without a recommendation from the planning board. So the planning board's recommendation is truly an intermediary step that I don't believe rises to the level of a decision, because they could have recommended approval, they could have recommended not approval to the final decision maker, City Council, and they could have also not acted. And then that information, that minutes from their hearing, would have been the planning board declined to make any recommendation on this, and it still would have moved forward if it hadn't been withdrawn.
So the judge pointed out that step 5 indicates language, public hearing and recommendation by planning board. Step 7 then states public hearing and final decision by City Council. That's what you're keying in on, the recommendation and decision language.
That's correct, and that was in the language prior to the June language amendments.
So why was there need to clarify?
That's a very good question. The reason to clarify is so that we don't waste judicial resources and governmental resources and taxpayer monies and plaintiffs' time and effort in having to argue this all the way to the Court of Appeals about whether or not a recommending body that is only a recommendation is in fact a final decision maker. It's just easier to clarify the law or the zoning code at that point to make that clear, and so that we don't have to continue to have this argument.
So anyway, that amendment could be read 2 ways. I mean, you could interpret it 2 ways, that, well, we said decision before, and that's all we meant was decision, not final decision. Or it could be read to say, we said decision, but our real intent was final decision. at that time.
And, Your Honor,
So-
that's exactly right.
And that's not before us.
That's correct. So, yeah, so they could have done that. But again, to have the plaintiff's interpretation would mean you would ignore the other three steps. And if you take plaintiff's interpretation, not only would the planning board decision be appealable, but so would the recommendation by the manager of community planning development. So would staff's interpretation or staff's decision that there was a complete application. There are lots of steps in the text amendment process, and is every one of those steps a decision that's appealable? That can't be the result, and that can't be the reading of the entire zoning code giving meaning to all 7 steps. That would just lead to an absurd result and with no certainty for anybody.
Counsel, I definitely see the point that you're making there, but how do you respond to the plaintiff's argument that if there's no jurisdiction here, no standing here, that the actions of the Planning Commission are never subject to review by a court? He says that the city has taken the position that once the zoning occurs in the city council, that you can't look back at the actions of the Planning Commission. Do you agree with that, that you can never look back at that, even if it's egregious misbehavior, as alleged, of someone voting that has a personal interest?
Well, Your Honor, that's assuming that the facts that they allege were true on the conflict of interest. But because the planning board is only a recommending body, this court must look to the final decision maker and the actions taken by that decision maker. City council is the final decision maker. They never heard this. So how do we know how city council would have interpreted the impacts? How do we know how city council would have applied the review criteria in adopting that?
I understand that, but you're not responding to my question of how can the actions of the Planning Commission be reviewed if you've taken the position that they can never be looked at after the City Council acts? Because obviously the actions of the Planning Commission are important. They're part of the process, and they obviously are information sent to the City Council on which they probably depend and act. And he says that can never be looked at based upon your position. How do you address that?
The fact that the planning board cannot be reviewed as a recommending body, they can't be reviewed because it is really only the information and the decision of the final decision maker, City Council. What went on below, the reason why recommendations are not appealable is to give the administrative process a chance to correct any errors. And so what went on below is, I hate to say this, but it is irrelevant. The only thing that matters in a text amendment is what City Council, as the final decision maker, the only body that can approve a text amendment, what they rely upon, how they rule in that situation. So a planning board recommendation is not relevant. The need to go back and to review their recommendation is not what a court would do. The court would look at what City Council, the decision maker, actually did.
This may require some speculation, but I still have the question of if after the planning board made its recommendation, LRA had proceeded to develop the property based upon that recommendation from the planning board, what would have been either plaintiff's recourse or the city's reaction to that?
Well, first of all, again, it's only a planning board recommendation, and it takes City Council action for the text amendment. Now, a text amendment, again, is only words that sit on the shelf in the zoning code that are not applied to the ground until there's a separate rezoning approved by City Council. The only thing that was appealed here was a withdrawn text amendment. So LRA could not have gone out and developed on a planning board recommendation because, first of all, there was no language for them to develop under, and second of all, and most importantly, there was no rezoning of that land into any language in the zoning code. So the plaintiffs are 2 steps removed from actually having a case of controversy.
And the judge, I found in the language in her order, CPD requested by email that the Lowry text amendment be withdrawn from consideration. So the judge knew that had happened.
Yes, sir, that is correct.
Okay.
And so, again, I just want to emphasize that this is an appeal of a recommendation of the planning board on a now withdrawn text amendment. It was never heard by City Council, it was never approved by City Council, and it was never applied to the ground.
What's the impact of the map amendment that Mr. Kerwin is talking about? I know that issue is not before us to make any decisions with regard to the map amendment, but Mr. Kerwin is arguing that it has some impact on what we're doing here today.
Well, Your Honor, again, you're absolutely correct. This case did not involve a rezoning, it involved a text amendment. But there was later a map amendment, a rezoning, that was put forth by the Lowry Redevelopment Authority that went through the 7-step process for approving a rezoning, ended up at City Council, and it was adopted by City Council, and that rezoning action of City Council was not appealed.
And that was rezoning of the 2013 General Development Plan?
No, sir. That was rezoning. The General Development Plan is part of the city's web of adopted plans. So what the rezoning was that took place after this was the rezoning was to zone the property that was originally zoned 01, which was airport, and because it was a Lowry Air Force Base, was zoned 01. I digress, but it really took that. It zoned that land into CMX5 with waivers. CMX5, again, is part of the zone district's words on the shelf that are in the zoning code. The with waivers was the waiver of it was the rezoning reduced the height from 5 stories to 3 stories in certain portions of the property that was in fact rezoned at that later date. So that's what went on at that point in time. And plaintiffs didn't appeal that. Nobody appealed that. An appeal of that final action of City Council to actually rezone the property would have been a better case to do.
That's a done deal.
That is a done deal, and it's not appealable. But at least in that case, you have an actual piece of property that you can determine if the plaintiffs would have been injured in fact. Were they close enough? Were they adjacent in fact to this piece of property? But how can you be injured by a mere recommendation, by words that were never adopted and applied? How can you have a legally protected interest in a recommendation with words that were never adopted or words were never applied? How can you ever have standing in those cases? So the rezoning case would have been a better case to raise these issues, but it was not appealed and is not before this court.
Thank you, it's Miss Avila.
Aviles.
Aviles.
Aviles, yes,
Okay,
sir.
Aviles. Thank you. I see your time has expired.
Thank you.
Thank you. And Mr. Kerwin, you have about a minute left, or a little less than a minute.
Subject to the court's questions, I'd like to try to address 2 things. First, on jurisdiction and ripeness for the Rule 106 claim, maybe we got lucky because we appealed it before the city tried to clarify their language last June. But the plain language of the Denver Zoning Code and text amendments talks about a decision. And as Judge Nieto pointed out, a decision by the planning board was a critical part of this process. The second point, I think we could have filed the second and third claim independent of the first claim. We filed them together as one lawsuit. And if you picture the declaratory judgment claim as a standalone claim, the Lowry planning process is the culmination of about 20 years of planning. And the fundamental conflict came right out of the city attorney's mouth. She calls the GDP, the General Development Plan, part of the web of adopted plans. That's where we are completely at loggerheads because the Denver Zoning Code tells courts that zoning has to be consistent with adopted plans. Adopted plans means adopted by the city council, and a general development plan is not. And instead, the city is proceeding with zoning the way it wants under this 2013 general development plan that is part of this web. The last thing I would say is that residents can't move quickly enough to challenge something like this. So you asked about the zoning approved, the map amendment, and within weeks, the developers out there with bulldozers changing the terrain, and we can't post a bond to stop a multi-million-dollar development. So instead, we tried to bring this legitimate legal controversy to the courts at a time very late in the 20-year planning process through a declaratory judgment claim independent of the Rule 106 claim, and we were told no standing. And that's the reason for the separate challenge to what the trial judge did here.
Counsel, doesn't your argument kind of put us in the position of acting as a super planning board or a super zoning commission to act on, to tell the city that you can't do these things when in fact there's no actual injury in front of us to review? It sort of feels like you're asking us to act as a super board, and that's not the function of the court. We're supposed to look at actual controversies, actual injuries.
I recognize, Judge Nito, you have to have an actual controversy to have standing. The super legislature argument, I think, is a red herring because zoning is quasi-judicial. It is not legislative. It is not call your favorite lobbyist and get them to lobby the city council. It is the city council needs to hold quasi-judicial hearings after the planning board holds its own quasi-judicial hearings and make decisions based